In a previous blog, I spoke to you about the fact that if you've been injured through the negligence of another, you should treat those bills as you would any other healthcare expense that you might have, and that is submitting them to your health insurance provider. As mentioned in the previous blog, your health insurance provider has negotiated a discounted rate for those healthcare services, and you should take advantage of that discounted rate regardless of the reason that brought you into care. When you come into care as a result of a personal injury claim, be it a car crash or some other type of claim, your insurance policy with your health insurance carrier likely includes a clause called a subrogation provision. That subrogation provision provides that the health insurance carrier can recover from you any sums that you receive from the person that injured you. So in other words, if you collect from another person for your injuries and your insurance provider paid for the medical bills associated with it, they have a right to get their money back. But here's the part that works for you. Let's say that your health care claims totaled $60,000. I'm making these numbers up for purposes of the hypothetical. As a result of the contract that the hospital has with your health insurance carrier, you will only be billed for $40,000. They've negotiated a $20,000 discount as a result of the provider agreement that exists between them. If we collect for you, we get to collect the entire $60,000 that would have been billed originally to you. The health insurance carrier then has a right to collect 2/3 of the $40,000 that has been paid by them to the hospital. And so the difference between what we have to pay back to the health insurance provider and the $60,000 in bills that you were originally billed by the healthcare is to your good. And why is that the case? The reason that that is appropriate and right under Illinois law is that you paid for that discount. You pay premiums to that insurance company who negotiated that agreement. As a result, it is you who should benefit from the reduction obtained through the premiums that you paid. What we're seeing more and more that hospitals are trying to subvert that system. They're trying to direct bill to the automobile insurance carrier, or sometimes refusing to submit those medical bills to the health insurance provider. We fight that every step of the way because we're always fighting for you. And we're fighting to maximize the return on the compensation that you deserve. So those things ought to be fought. There are ways to fight them. In fact, one of the ways we're fighting them is I am working right now with lawyer groups and legislators to try and draft legislation that would prevent that sort of thing from happening. In the meantime, however, we fight these vigorously through contested lien actions and otherwise so that we can maximize the benefits you receive for the injuries that you suffered. Again, if you have questions on these matters, don't hesitate to call us. Both certainly our attorneys, but also our legal assistants are very knowledgeable and possess a lot of expertise in addressing these medical bill issues and certainly the medical lien issues.